Headlines of a case between Mark Shuttleworth and the South African Reserve Bank got some of us thinking about the laws that regulate the movement of money. Well, yesterday, the Mandela Institute at the Wits School of Law hosted a workshop to analyze South Africa's decision to abandon the regulation of foreign investments through international instruments in favor of national regulation. What is the implementation, or the implication at least, of that decision? From the International Investment Initiative World Trade Institute at the University of Bern, let's welcome Dr. Stephen Gelb now to explain that for us. A very good morning to you, Doctor. Thanks again for your time.
Thanks for having me, Ayanda.
Why should ordinary South Africans care about the way in which money travels across borders?
Well, it's about the issue of, one of the big issues, I should say, is the question of whether governments can introduce policies and regulations which they wish to do for their own political reasons, and what effect that might have on international investors who have brought money and started businesses in their country. And the situation has been that international investors, if they feel that their rights have been infringed upon by policy changes, can take the government to court in an international arbitration situation. This happened in South Africa about 7 or 8 years ago, where the government was sued by an Italian mining company over the BEE policy. And it was as a result of that case, which was eventually settled, we don't know the exact outcome, but the government then decided in 2009 to rethink its whole approach to this issue. The similar thing is actually happening in Germany, where the German government is being sued by a Swedish company that provides electricity in Germany, because the German government, after the Fukushima nuclear disaster, changed its nuclear policy. So the Swedish electricity company, which has been using nuclear stations in Germany, is now feeling that its rights have been infringed to sell electricity in the German market. But the German government, and I think many people in Europe, feel firstly that this is to pressure the situation where governments can't change their policy. And they feel also that if, for example, the Swedish company wants to sue the German government, they should do it in a German court, not in an international arena.
It sounds like a terribly complicated issue. You just mentioned that it is one of those that tops the agenda as far as European politics are concerned. It is a hot potato there. It seemingly is not just an economical aspect. There are politics involved, but can it also be socio-economic? Can it affect perhaps a country's tax pool and the services that it provides when people take money elsewhere?
Well, it does, because in many situations, foreign companies provide services to the population of a country, and if they feel that they're not able to make the sort of profits that they hope to make because of a policy change that happened in the country, as in the Swedish electricity company, then they can take action against the government. But of course, the supply of electricity and how the electricity should be supplied is a question of big interest to the local population of Germany. The BEE policy is, of course, a question of very much interest in South Africa. So it impacts on socioeconomic issues as well as the sort of more specifically economic and financial issues.
I know a workshop was underway to analyze South Africa's decision to abandon the regulation of foreign investments through international instruments in favor of national regulation. What were the outcomes of that gathering?
Well, it was there was a discussion about the situation and whether or not it's appropriate for South Africa to take this approach, which when South African government took the approach 4 or 5 years ago, it was 3 years ago, it was a rather new approach, but since then other governments have done the same thing. The German government has more or less moved to a similar position. The Indonesian government is taking a similar position. So at the moment there is a bill in the process through the South African legislative arena. At the moment it's sitting in NEDLAC. It will eventually go to Parliament in a few months. It had been published a year ago. This is the revised version. And so we were essentially discussing the merits of the bill, as at least the public version of the bill, and whether or not South Africa should adopt this sort of policy and how to implement it and so on, whether it'll work out in the future. The outcomes were, well, there weren't specific outcomes in the sense that it's going to directly affect the process, but it was more to give the legal and academic community a chance to develop their views on the matter.
What was your position, if you're at liberty to tell us what you think South Africa should do, what its position should be with regard to that bill?
Well, I think that it does make sense in a country like South Africa, where we've got a very well-developed judicial system, independent judges and so on, that foreign companies should be able to take their legal concerns and disputes up in the domestic court system. So broadly, I would say that I support the general thrust of the bill.
Dr. Gelb, a huge pleasure to have you with us. Thank you so much for having joined us. A quick ad break. Morning Live continues after this.